Good to be here.
Thank you for coming. I think we should start. It is 11:01, Wednesday, August 28th. And it is now 11 days past when this NAR changes kind of affected nationally, but it's 28 days. Am I right about that? Has it been almost a month since the local MLSs have taken off the compensation? I think that's right. Yeah, it started August 1st, right, Mike?
Yeah, give or take. Marco was a little earlier, I believe, but yeah.
So let me see if I can just set this up correctly. Add spotlight, add spotlight, add spotlight. There it is. Okay. So there's been a lot of moving pieces here. We've learned a lot. In fact, they've actually updated the NAR FAQs. I was looking at them last night. They've got some on there that were updated August 16th that I saw. So honestly, if anyone has questions and they don't want to rely exclusively on the advice of others, if they want to do the research themselves and just have some of that comfort, or if you want to send your buyer to go look at them and see it for themselves, like I heard this morning, the NAR FAQs are very good. I don't think they're perfect. I do have some concerns with a couple of their answers. Dad, tell me about one of your concerns you brought up about the NAR FAQs, that they're basically one-sided, right?
Well, it's the defendant's interpretation of the settlement agreement. There's nothing from plaintiff's counsel. There's nothing from the Department of Justice that's just sitting to see how this all works out. So it's like the settlement to any lawsuit where you get one of the parties saying, if you do it this way, you're going to be fine. Well, okay. The enforcers for these practice changes is Naples Board of Realtors and the various boards throughout the country. So I guess on a temporary basis, from that perspective, you're okay if you're following the strict letter of the settlement agreement. But the settlement agreement is so darn thin, it's so short, and it doesn't cover every possible scenario in every form we're looking at. Is is this working with? Is this the 4 requirements? The pre-touring agreement, for example, that we wrestle with so much. It doesn't say in the settlement agreement, so we have to try to figure that stuff out. I mean, it's just the sheer volume of not only data, but the forms interpreting that data that we have to read it and see, is this right? Does this comply? Does the board agree with this?
Generally, the point that we're trying to make is that this is one party's interpretation of that settlement agreement. And it's changing all the time, the way that they do it. It's a tough situation that NAR is in and that we're all in, right, because they have to actually interpret this to use it, whereas the plaintiffs get to just sit there and wait for you to mess up. So not the most fun situation to be in, but I still like the FAQs. I think they do a decent job.
Oh, they're helpful. They're extremely helpful. But
and in regards to the MLS, if you were to ever have to defend your actions, if you could revert to, hey, this is what I relied upon, the FAQ number 63, and that's what I did. That's really great. I think that is huge. And honestly, you should probably take that route over even the advice that we give you if it were to be in conflict. I noticed last night that there were a couple of things in here that, Dad, you and I actually wrote kind of the opposite on.
Yeah.
And that is specifically regarding Bill's question. So Bill, right before this call started, he brought up the scenario where he has a couple of lot listings, and he is the listing agent, and a buyer who is unrepresented reached out to him and said, hey, I want some information. It's not that they want to tour the home. There is no home, but I want some information. And Bill's a little nervous as to how involved he can be, how much information he can give. And so we wrote an article, Dad. We called it Good, Better, Best. Let's see if I can find it for us real quick. But if you aren't getting those articles, you should email us. My email is christian@rosstitle.com, and I can add you. The lights are flickering, so hopefully I didn't lose anybody. But this good, better, best, it was a really great article. The premise of it was that if you are the listing agent, how are you going to do this? If a buyer reaches out and they don't have an agent on their own, can you work with them? Or what does it mean to work with them? So here's the article. Good, better, best open house strategies. We talk about the FAQs. Dad, walk us through this. The good was basically if the buyer doesn't sign anything, right? What can you do? What can't you do? Right?
Right.
This is something that I thought was interesting. The FAQs seem to differ a little bit on us. I'm trying to think about where it said it.
I'm looking at 65. You can have the open house. 67, what's a ministerial act, according to them? You know, to answer Bill's question, you know, can you talk to somebody over the phone? 67 seems to say, yeah, because you know, if it's ministerial and they have not taken the buyer to tour the home, so therefore is not working with the buyer at that point, so you don't need a written agreement. That's according to FAQ 67.
Yeah, so 65 says, is an MLS participant, which would be you guys, if they have an open house and they provide access to the property on behalf of the seller only to an unrepresented buyer, will they be required to enter into a written agreement with those buyers touring the home?
Right.
And Bill, to your question, the answer is no. In this case, since the MLS participant is only working for the seller and not the buyer, that person does not need to enter into a written agreement with the buyer. So initially, if you want to, you know, kind of show them around in a sense, answer some of their questions, kind of help them through a little bit of that, I think that's fine. And number 65 is what I would rely upon. I'd save that for your file so you can always go back to it. The question then is, so Bill's covered under his question, he's fine. Call him back, answer his questions, try and make the deal happen. That'd be great. The rub is when they ask you to draft a contract or make an offer. And that's where it gets a little sticky. If you look at 67, like you mentioned, Dad, are written buyer agreements required when MLS participants perform ministerial acts? And the answer is yes. The obligation to enter into a written buyer agreement is triggered just prior to MLS participant taking a buyer to tour home, regardless of what other acts they perform for the buyer. An MLS participant performing only ministerial acts and who has not taken the buyer to tour home is not working with them. And maybe that's not exactly the one I was pointing to. I wish I could find this. Of course, I'm doing this blind a little bit. Oh well, I'll have to find it. But there was an updated one that basically said that if you're going to work with the buyer in any sort of way to help them draft a contract, to help them put the deal together, you do need a written agreement. So let's explore that a little further. In our article, we suggested that it is possible that you could be just the listing agent, earn the full compensation, and not have a buyer brokerage agreement, as long as you weren't representing the buyer, right? But it's not ideal. And so that was our good situation. That was like, all right, you tell the buyer, go, hire an attorney, or, maybe I'll put the offer together on behalf of the seller and then you guys can review it. But it is, you have to be very careful not to be working with the buyer. You can do things on behalf of the seller. You can do things on behalf of the closing. But, on a sales contract, don't put yourself on both sides. You're only representing the seller.
My concern with that, Christian, is that your idea of what working with means and the buyer's idea of what working together means are going to be 180 degrees apart. They don't understand this, and we're just beginning to understand it. And when you look at FAQ 61, it almost shows a slippery slope. I mean, you can, if you're just representing the seller, you're just doing ministerial stuff, you're fine. But once you go beyond that and start providing additional brokerage services, whatever the heck that is, and negotiating, showing other property, they give some examples, then you do need a buyer brokers. So you're engaging in a slope where it's not a clear red line as to, okay, now we've gone too far. We've gone beyond just working for the seller. We've gone beyond just ministerial. So to be safe, to avoid any possible argument against the realtor, it's good to have the buyer broker agreement.
Okay, so we agree with that. So let's keep using Bill's scenario. Bill, you feel free to answer their questions, let them see the property. If it's a actual home, you can tour it with them because you are the listing agent. But we really don't want you doing a whole lot more than that if you are the listing agent, because anything more than that, even if I think you're not working with the buyer, I don't want MLS to say otherwise. I don't want some of your competitors to claim that you're working with the buyer without an agreement. So, there is a limit to how much you really should do to protect yourself. So what we really want you to do is that at that point, the buyer says, hey, we want to make an offer. I think you have a couple of options. In the very least, the best option is you have them sign an exclusive buyer brokerage agreement. You specify how much you charge, you put a term on there, and then you have the buyer sign it. That would be great because it outlines all the duties that you're owing to the buyer. Right. You're 100% protected. You don't have to make that argument that you're not working with a buyer. It's 100% a perfect solution for you. But maybe the buyer doesn't want to do that. I had a call this morning where the buyer said, I don't want to sign this. Why do I owe you anything? We're just kind of kicking the tires. In that scenario, we do have a solution for you. And that was under our better solution. So the best solution is a full-on buyer brokerage agreement. The better solution was to put more of a limited buyer brokerage agreement. Dad, to explain to us what a limited buyer brokerage agreement was in our article.
Trying to remember what we put in the article.
Oh, well, here it is. Put 0 for compensation. Right here. So
you can put 0, and I would suggest you warn them heads up that if things work out, you get along and all that, you're going to come back with an amendment asking to be paid.
Well, this is again, Dad. This is as a listing agent, right?
Oh, as a
listing. If we think about it,
you're right.
The listing agreement says a total compensation, which you can elect to share a certain percentage of that with the buyer's agent. If you are the buyer's agent, you could play with the numbers a little bit. You could earn 5% as a listing agent and 1% as a buyer's agent. It could be 6 and 0, 5 and 0, 3 and 3,
4 and 2.
It doesn't really, if you're both sides, if you're representing both buyer and seller, this would be fine. So if you wanted to just get the buyer in and protect yourself, put 0, add in your transaction fee so that you can at least charge them that. And then you could also limit it to that specific property. So you could say, because really what we're trying to do is we're trying to get this buyer to trust us. We don't know them, they don't know us. We're trying to keep that buyer from maybe going and talking to another realtor. We'd love to just make it all one deal. And I honestly think that it goes smoother sometimes. And so this was how you would limit it. And then you can also limit it by shrinking the term. You could do 1 day, 1 week, 1 month. It doesn't have to be the perfect solution where it's 1 year or something else. Dad, this part I think is interesting. And I'm going to warn you about it because I'm going to come to you, is that the protected period. All right, so to review, the best case scenario is a full-on buyer brokerage agreement. You've converted this cold call, this person who just knocked on the door, you've converted him to a full-on client that has agreed to full compensation for you and your brokerage. And over a 12 months, 6 months, or 1 month scenario. So you're going to, if this house doesn't work out for that buyer, you'll go spend next weekend and find them 5 others that they might like. Yeah. And that way that is our best case scenario. If that's asking too much, they don't want to commit to you in that way. In the very least, you could do 0, you could limit the term, you could limit the scope to just that property. How does protected period play into this, Dad? Because what if you did do 1 day buyer brokerage agreement?
Well, the default language in the exclusive, I think, is 180 days. So if you show them the house on that one day and a month later, 29 days after it's expired, they enter into a contract with the seller, you get paid, which you would anyways with the listing agreement.
Yeah, what if we only put 1 day?
1 day for the protection period?
Oh, no, for the term. So, okay, we were on a different page. So terminate on. So let's say today's the 28th of August. We put August 28th, and we say it terminates on August 29th. So it was a 24-hour agreement. Then they specify buyer incident, where is the protected period? Is that last sentence?
It's
If
the
during
default of
the
180
blank days, there at the bottom, if during the blank day period
Okay.
after the termination date, buyer enters into a contract to purchase or lease any property toured by buyer during the term of this agreement, then buyer will pay broker's compensation as set forth above, and this agreement shall automatically be extended. So that's our protected period. That is what that would be. It's very similar to how the listing agreement is, but it's actually a little bit more open. It actually
Yeah.
gives a little bit more because it can't be cut off based on the terms of this. So it's 90 days by default. So if you did a 1-day buyer brokerage agreement at 0, you show them the property and they're like, I don't know, I'll get back to you, right? That 1 day goes away, and then they go and they talk to another agent, and they come to you with another agent now and want to make an offer. You'll have to have that conversation with them and say, look, we have a buyer brokerage agreement that is still protected. You're still at 0. I was still the procuring cause. I was still the one broker here. You have this duty with me. And I think you could probably keep that deal as like, hey, I put this whole thing together.
And that agreement doesn't even call for procuring cause. That's the broker exclusive.
Right,
Yeah.
it does. It's the exclusive. So any property that they find. Now, if you limited it to just your property, then it's just that property, which would be fine.
Yeah.
And the fact that it's at 0% is fine too, because you're the listing agent.
Yeah, you don't have procuring cause to deal with until you have the broker to broker agreement.
Right. So I think that would be, it's a really great option where there's no pressure for a buyer, but it does require a sense of loyalty, especially on this one property. It's like, look, you don't know me, that's fine. Let's come, let's see it, just so that I'm covered. Let's have you sign this. It's a no obligation thing. It says 0%. It's for 1 day. But if they were to try and go around you later and make a deal direct or use another agent, you would have that extra protection there. Mike, have you heard anything like that? Have people been kind of worried about that?
I really haven't heard any chatter about that. Mark Borg just threw something up on the screen. I've heard a lot about what he just threw up.
Bring it up. What did Mark say?
What happens if the buyer signed multiple buyer broker agreements? And yes, it is happening. And theoretically, they could be on the hook for multiple commissions.
Yes, absolutely. So the way this buyer brokerage agreement works, you look at buyer's role, and it says the buyer agrees to the following: work exclusively with broker and be available to evaluate or view properties. So the buyer would be violating their agreement with you, which puts them in default, and you could possibly go after them with certain remedies. But like you said, Mike, the buyer is obligating themselves to multiple agents.
There is a best practice, and the best practice would be everyone should ask their buyer, have you signed a buyer broker agreement with anyone else? And I would note your file that you asked the question and this is what the answer was. That way, when they try to blame you that you never brought this up or something like that, you've got that in your file saying, no, wait a minute, I did bring it up, and this was the answer you gave me.
I would go beyond that, Mike, and just ask if they signed anything with any other broker, because they may not fully understand what they're signing.
They might have done a pre-touring agreement. You don't know.
Correct. So it's funny. I found a lot of success comparing the buyer brokerage agreement to the listing agreement. They actually work the same way. It's exclusive, and the buyer and the seller obligated to work with you exclusively. They're obligated that if they want to make an offer or if they want to accept an offer, they have to go through the realtor. They have to share that information with the realtor. So I try and take the wind, it's not taking the wind out, I guess, but I use that to convince them that this is not unusual. This is something that's been in the listing agreements forever. This is exclusive. This is the only way it really works. I'm exclusive with you, you're exclusive with me. David asked a great question, and I love this question. How do we explain to buyers the contradiction on the forms that the language that all commissions are negotiable, yet we are telling them our fee is X? Seems that once they sign this agreement, the commission is not negotiable unless both parties agree. Mike, what do you think of that? You were just at the Florida convention, Realtor convention last week. Did they touch on any of that?
I caught the second half of it. I didn't catch the first half of it. What is it? The question
He's
again?
saying there's a bit of a contradiction because we have to say it's negotiable, but once it's signed, it's not. You know, it's set.
In my mind, it's negotiable up to closing. I mean, you can put a modification in there, and they might agree to it. They might not. They might come back with a counter. But I'm not the attorney. I defer to you and Donald.
But I think that it's not really a contradiction. You know, in negotiating the terms of your buyer brokerage agreement, everything is negotiable. And nothing is off limits. But once we sign an agreement, then I'm obligated to you and you're obligated to me. I think that's normal. I think that's very common. I can see why you might see it as a contradiction. It's really just, I think it's more ironic that we have to scream it from the hillside that it's negotiable. That's all. I don't think it's true.
It's like a sales contract. The price is negotiable until you sign
Until
it.
it's signed it. Yeah, buy a car, buy a house, everything's
Yeah,
negotiable.
the commission
until-
is negotiable, the compensation is negotiable up until they sign agreeing to pay. And then using your factual scenario, Christian, it's that one house for one day. So if there's 4,000 buyer broker agreements, but they're with different houses.
Yeah.
That's not a problem.
Yeah, not a problem. And that's, I would avoid signing multiple buyer brokerage agreements, either from the buyer's perspective or the broker's perspective. I think that, you know, I've heard some people say, I have one major buyer brokerage agreement that says one thing, and then depending on what property I go to, I'll do a separate just for that property. And it's based on what the listing agent is offering. I would not do that. And the reason I wouldn't do it is because you have these overlapping legal contradictions. You have conflicts. You have one agreement that says 0 and another one that says 3. Which one rules? And in you know, possibly in the legal world, they both get wiped out. I would say if you do something like where you're going to do multiple agreements, I would either amend it, that would probably be my preference, or I would make them specific. All of them would have to be specific. So it'd be like property 1, 2, and 3, we can have separate. Just don't have a number 4 that's for everything. Does that make any sense?
Yeah, I would agree with you, Christian. The other thing is if they sign multiple buyer broker agreements with you with different percentages, and all of a sudden they're in a situation where they have to come up with the money, which number do you think they're going to remember? They're going to remember the lower one.
Yeah, Dad, you used to do estate work or probate work. What if they found 2 wills? It's a problem.
Yeah, absolutely.
Another kind of caveat to that or add on to that is we do have where a buyer really freaks out about feeling obligated to this compensation. If you did put 3%, that they're like, well, I didn't agree to pay that. And what I like to do is I want to point them to paragraph 5. And it's right here. It says, provided, however, broker is authorized to negotiate for seller / listing broker / landlord to pay all or a portion of the compensation. See, that's our goal. That is exactly what we're going to do. I'm going to negotiate to have the seller pay for this, and it's going to be part of the deal. And if for some reason the seller refuses or they're offering nothing, we will have to bake my compensation into your offer price. So if you were going to offer this, we're just going to offer a little bit less, knowing that you're going to have to pay the compensation. And Dad, that's very similar to title insurance. You know, on the FAR form, you check the box,
Right.
who's paying, buyer or seller. And on a $1 million deal, it's a $5,000 swing. So if the seller's paying the title insurance, you can offer a little bit more. If the buyer's paying the title insurance, you're going to stay to that lower number. Maybe it makes you a little uncomfortable because you never had to do that before, but it's fine. I do it on pretty much every day when we have to give fees, and so the buyer and seller just have to bake those into their math.
The interesting part of this paragraph to me is that the seller concession could be used towards payment of the broker's compensation if there's not enough broker's compensation agreed to by the seller. I just wonder in real life, I mean, how many sellers are offering sellers concessions to the buyers up front? That's like almost telling a buyer, okay, I'm listing the house for $1 million, but I'll give 3% sell concession. You're telling up front.
I will say they do it in other markets. In this market, there's not even a field for seller concessions, so you're not going to see that. But in Atlanta, where I used to practice, seller concessions were the norm. They were common. You would always ask for 1 or 2% in closing costs. Very common, and it was kind of baked into the deal, and everyone kind of expected it.
Is that part of the offer, Christian, or is it?
Yeah, it's part of the offer. Absolutely.
Yeah. Here it's, part of knowledge of, I guess, if the selling agent calls the listing agent and asks, what about seller concessions? Now the buyer knows that the seller is willing to go down X%.
Yeah. And in other markets, it does work like that more strictly because it's on MLS. They'll put right on MLS 3% in seller concessions, so what the compensation being offered is. You don't even have to call them. That's not the case in this market. We're not allowed to do that. So that it's just different structure, different folks. I don't think that part alarms me at all. The whole point is we've got to make sure that the buyer is aware of the fee that you're charging, that it is negotiable, that they are aware, and that they sign off on it in advance. That is the key. So David actually said Stellar MLS had a checkbox for seller concessions and they removed it. I hadn't heard that. That's very interesting. I assume they removed it because they started getting nervous. They started getting nervous that it was something that was going to put them at risk of being sued for violating this somehow.
It's going to be perceived as a workaround.
Well, yeah, and even though it was allowed in the settlement, it just feels like a workaround. It totally feels like one. Even the way
you're just calling a cow a pig when it's really a cow.
So Sigrid has a great point, and Sigrid and I were talking yesterday a little bit, and she had some wonderful scenarios that we went through. She says NAR was telling us in a meeting that that if a buyer comes to an open house and has a buyer brokerage agreement with another agent, we should ask for the agent's contact information, give the property information to the buyer's agent, and let the buyer only tour the home, but no information should be given. Interesting. I think that, like Mike said, you do ask whether you're working with an agent. So it's probably one of the first questions. Are you working with an agent? And I'll make the analogy to attorneys. We have to kind of ask that same question. As soon as we know that they're working with another attorney, Florida bar dictates that we have to work with that attorney. We can't talk directly to the customer.
Right.
Because that would be a bad faith or unethical violation there, or an ethics violation. So I think that NAR is giving you advice so that you don't commit some sort of ethical violation. That being said, don't make it awkward. You have a buyer right in front of you. You've asked them if they have an agent. You've gotten that agent's contact information. You'll reach out to them right away, but you have a buyer right in front of you. Be kind, be courteous, show them the property. If they want to take a brochure, great. If they want to talk about strategy and what would the seller accept, and I would say, just like you would before, you're saying, why don't you talk with your agent and get back to us once you guys have confirmed, because I don't want to negotiate without the agent involved, and I don't want to give information that would be inappropriate. I think you would have said that before as well. Right, Deb?
I agree. Again, I listened to all this, and we have what the law requires, what the settlement requires. That's sort of the minimum. We see the different boards going above and beyond that, which you and I, Christian, see with title insurance. You know, often the underwriter will ask for things that the statutes technically don't ask for, just because they want to avoid the possibility of litigation or the possibility of a misunderstanding. And that's really the gist of like the past article from Sunday. And that's the gist of why you want to be crystal clear with the buyer that you work with the seller, because they're going to remember it differently. I can almost guarantee it. If it's to their financial best interest to say you were working with them, they're going to say it. So cover yourself and go beyond what the statute requires to be safe. And you might actually pick up an additional customer.
Keep in mind, guys, that and a minor point here, and I agree with what Christian's saying about being courteous, and you don't know when that other buyer broker agreement expires. So if they liked you when they met you at your open house or whatever, being courteous goes a long way.
Oh, sure.
Well, and be careful, because expired is only half the battle. What about that protected period?
Yeah.
That matters, right? That
Yep.
really matters. Yvette saved me, by the way, so I will give her a lot of credit here. She pointed out what I was looking at, 82 to 84, you know, on the NER FAQs. These were updated just recently. Number 83, is a written buyer agreement required if a transaction broker, which we are in Florida by default, who is facilitating a transaction for a seller, aka you are the listing broker, provides an unrepresented buyer with access to a home? It says no. The transaction broker would not be considered working with a buyer in that situation, and therefore a written buyer agreement would not be necessary unless required by state law. I think that's huge, right? So there's your comfort. You don't need a buyer broker agreement in advance of a showing if you are the listing agent. It's right there, and I agree with that. I think it makes a ton of sense.
What does that mean, though, Christian? Does that mean opening the door and letting them walk through, or touring the house with them?
You know, it's just provides an unrepresented buyer with access to the home, opens the door.
Opens the door and lets them
house.
look around on their own, or you know, your owner wants you to be there to make sure everything's okay.
Right. So here's number 84. If a transaction broker, so this would be the next step. If they're facilitating the transaction for both the seller and the buyer, is a written buyer agreement required prior to touring a home? The answer is yes. I don't think that makes any sense. What are they talking about?
Yeah.
The MLS participant is working with a buyer and a seller, so a written buyer agreement is required. But the question says prior to touring a home. What? You just told me before that I can open the door for them without a buyer brokerage agreement. But if I open the door and they love it and want to make an offer and want to hire me, it's too late. Can't work that way. I think that.
And what in God's name does facilitate encompass?
I don't know. Well, that's the other question. What does it
Anything
mean?
is facilitating, saying hello. Here's the key.
All right, so here's number 82 as well. Is a transaction broker facilitates a transaction for a buyer considered to be working with a buyer? The answer would be yes. Written buyer agreements do apply to transaction brokers. So all these were added just in the last two weeks or so. Maybe it was 3 weeks. I think there were even more.
Is this the August 8th one, Christian?
That's August 8th, yeah. So I thought that was really interesting. I think there's even more on there as to things that were updated. I don't know. That one's
See, all these words, working with, facilitates, it's a question of degree. You know, it's a question of what shade of gray have we hit, and at what point does that become black? That you are working with them, that you're doing more than facilitating. And their understanding and your understanding are going to be different. You know, the realtors are listening to us talk to try to figure out what the heck the difference is. You know, imagine the guy on the street who hasn't listened to any of this.
Well, so here's my advice to you guys. And you know, I reserve the right to change my opinion, and I will refer you to your broker for the ultimate decision.
It's Mike's decision.
Yeah. If it was
I gotta
me,
go.
yeah, if it was me and I was the listing agent, I would absolutely show a buyer a property without a touring agreement in place. Absolutely. Should I do that? Well, no, I'd rather have it in advance, and I'd probably put 0, and I would limit it to just this property, and I would use that as my opportunity to, one, be in compliance because I had a buyer brokerage agreement, and prove that I can sell this to the buyer, and I can help them, and I can convince them not to use another broker who, they may otherwise want to use if they didn't have a buyer brokerage agreement. So in a perfect world, I would invite them to the home, and either right before or at the home, I would ask them to sign a buyer brokerage agreement with a big fat 0, and I would try and work with them, knowing that I was getting paid the full percentage as the listing agent. In a sense, I'm doing both sides, even if I'm earning the compensation exclusively on the seller side. I think that's what I would do. And then in a perfect world, I would try to convert that buyer. If they didn't buy my house, my listing, I would convert them into a customer, and I would amend their buyer brokerage agreement later to a full percentage, a full compensation model. That would be what I would do. And that would give me the opportunity to have exclusive negotiations with this buyer, not only for my listing, but to keep them as a customer long-term. And I think that would have a huge impact. Mike, I don't know if you're seeing this or will see this, but in that scenario, if we can pull that off, I think listing agents there'll be one agent on a lot of deals because of that.
In my simple head, when we were doing this article, Christian, I just looked at it as an opportunity to blame somebody else, blame the settlement agreement, blame the plaintiff's lawyers, to say to somebody who walks in the door, gee whiz, to avoid any confusion, to comply with the law, here's a buyer broker's agreement. I do not want to jeopardize my license. I have to feed my family and so forth. I need something in writing because it's not crystal clear what facilitate means, and at what point is answering questions going into working with, a particular buyer. And if you go beyond that to potential litigation, realtors, lawyers, we're not sympathetic defendants. We just aren't. The poor man on the street, or the poor widow making an offer on a home, she's the sympathetic plaintiff. We're the unsympathetic defendant. So I'm always leaning towards covering them. At least that's how I've conducted my law practice, covering myself or covering the realtor.
I have another fun example. Mike, did you have something you want to add?
No, I thought Don was spot on.
Cool. So here's another scenario. We have a buyer and an agent working together. They have a buyer brokerage agreement signed because they're going around, they're touring properties. We hear about a person who may be willing to sell. It is, it may have been listed previously, but it's been terminated or expired. So or it was never listed to begin with. Historically, you would sign a showing agreement with the seller so that if you showed this buyer the property, one, you had permission, and two, you had guaranteed compensation with the seller because you were bringing this buyer. So that was the showing agreement. Nabor has one, FAR has one. It's less than a full listing agreement. It's just a showing, just for this buyer, just for this one day, but a stated compensation. I don't know if you should use showing agreements in that scenario anymore. I don't know, because a showing agreement is going to say, a certain percentage as a buyer's agent, as opposed to another, you'll have your buyer brokerage agreement. It's a little messy, especially, and maybe this is the only time it's messy, if it was an expired listing. And I'll tell you why. So you have an expired listing, it's just come off the market, they're not going to put it back on right away, but you want to show your buyer this. So you've got to cut off the protected period of that listing agent, that prior listing agent. And so a listing agreement would cut off the protected period of that prior listing agent. Would a showing agreement cut off the protected period? Maybe not.
I know how we've handled listing agreements where the protection period was not finished yet. Mike and I would encourage the agent to contact the prior, listing agent and say, I have this buyer, we can offer you $5,000 out of the commission, or if you're going to be difficult, we'll just wait till the protection period expires and then you get zero. So Mike and I have done that.
Well, and you
times.
could do a 1-day listing agreement. It cuts off the protected period, and right then and there. And then you're covered on both buyer and seller side stuff. And maybe you're not getting a full double commission in that scenario, but you are kind of controlling it. You're controlling the deal as opposed to having a third party, another listing agent involved that had just lost the listing. So something to consider. In that unique scenario where there was an expired listing, I thought the showing agreement wasn't the right move, and I actually recommended we use a listing agreement for just 1 day, and specifically because of that showing or the protected period.
You talking about the showing compensation agreement, the seller to broker agreement, Christian?
Yeah, it's called showing/compensation agreement for sale. Exactly. And it's possible, I am doing this kind of off the cuff a little bit. It's possible that this showing agreement cuts off a protected period. I don't think so, because you're not actually representing the seller in this scenario. You're bringing in a buyer. So you're not actually working with a seller. I think that's how this works.
The funny thing about that agreement is it doesn't call for arbitration with NABOR. It calls for litigation. The broker to broker does call for arbitration before NABOR. So whoever's being harmed in this situation with the showing compensation agreement, they're going to have to be willing to go to court, hire a lawyer, spend time litigating over the issue.
So Mark Schwartz has a great question for you, Mike. How do you feel about offering a buyer single agent representation to strengthen the assertion that you are fully representing their interests as their fiduciary? So what would you say? Historically, it's like 99.9% transaction broker. In fact, it's the default. What Mark is saying, does it look better if I'm a single agent, the single agency relationship with your seller? I think it's a great option, Mark. That would be my opinion. I think that given the possibility of a buyer coming without a broker, I would still prefer that you're all transaction brokers, because that allows you to sign up both buyer and seller and to be the one cook in the kitchen, the one man in charge. But if you're not going to get the listing because the seller thinks you've got your hand in too many pockets, that's fine. We'll do single agency. Happy to. Not a problem.
The problem with single agency is when you're showing a listing that's a Downing-Frye listing.
He'll have to do it
Downing-Frye's on both sides. Now you have to go to transaction.
Well, you would have to, or they won't be able to accept that offer.
Yeah.
That's the part I don't like about it.
Well, and the
problem
other
when you're
thing
a
I
big
don't like
brokerage.
about it is if you have another buyer who's interested in the property along with the person you're currently talking to, you owe loyalty and obedience to that first buyer.
So Mark just clarified, he wasn't referring to the seller, I'm sorry, he mentioned the buyer. So if the buyer says, hey, great, I'll sign your buyer brokerage agreement, but it must be single agency, you probably still have that same issue. If I show you a property that is listed by a Downing-Frye agent, or if you're a Compass agent and it's a Compass listing, you're going to have to amend it, otherwise they're not going to be able to make an offer.
Yeah.
And so if you tell the buyer that, you say, look, happy to sign single agency, let's do that first. But if we find something you really like, we will have to modify it. Otherwise, we're going to be excluded from offering on it. And say, look, I have no problem doing it that way.
They have a form for this anyways. You can transition to transactional.
Yes, exactly.
Just warn your guy up front that you might have to transition if it's a Downing-Frye listing.
Yeah, Yvette asked a question, says, does this apply to vacant lots? Yes. It doesn't apply, all these different rules, it doesn't apply to commercial. And interestingly, boat docks, I would say, are commercial. They're not residential, that's for sure. So that kind of leads to they're not under this MLS settlement. So if you do sell boat docks, I don't think this applies. Probably still safer to use a buyer brokerage agreement.
I think the
think
statutes define, if you go over a certain number of lots, and I believe it's 4, it becomes commercial.
Yeah, so residential, and if you guys remember from your real estate courses, residential is 1 to 4 units. And so that could mean a duplex, a quadruplex, a triplex, or just a single family or a condo co-op, things like that. So all those would be considered residential. If you bought an apartment building that had 8 units, if you bought a boat dock, if you bought a hotel, that's commercial. This doesn't apply to commercial.
I did ask the Florida Realtor Legal Hotline yesterday whether a buyer broker agreement applies to lots, because I had both answers, and they said it does not apply to vacant land lots.
Yeah, I don't agree with it. I mean, 0 to 4. Residential.
I would say that is not advice you should take.
Well, I asked, I said,
you
what
and I
if it's a
talked
big
about
tract of-
different, sorry, you and I talked about a different scenario. And the problem is, what if that lot is zoned residential?
I asked that, and the reason they gave me was it doesn't have walls. They didn't just answer it. They gave their rationale. To me, a buyer broker agreement is better safe than sorry. And think big. They might not buy that lot. They might buy something else. If you have a buyer broker agreement executed with them, it might help you if they go and end up buying something down the street.
I would say,
tell me if you remember differently, Christian. A vacant lot could theoretically be homesteaded because you can put a tent on it or a mobile home, something like that.
you can make, I've seen clients make that argument where they put a mobile home, they parked it, they took the wheels off, and then they claimed homestead. If it's zoned residential, I would not do it without a buyer brokerage agreement, because MLS is going to come down and honestly, you could get thrown in front of an ethics hearing even if you did nothing wrong. So it's tough. And we had a separate situation, Mike, that you and I were talking about. Florida realtors said, what would happen if you couldn't accept the full compensation that the listing agent was offering? So the listing agent's offering 3, yours only says 2. What happens to the extra 1? What happens to that? And Florida realtors gave you an answer. And I said, how do they know? They haven't read the listing agreement. They haven't read the sales contract. They don't know what's in the buyer brokerage agreement. They don't even know what buyer broker agreement you're using. How do they know? So I don't think there's not a one size fit all. You have to look at it. And if I was the broker on a buyer side, I wouldn't just give it to the buyer. I wouldn't just give it to the listing agent. I wouldn't just give it to the seller. I would just never accept it. Not my job.
The problem, I had my media relations committee yesterday where a lot of the big brokers were in attendance, and part of the problem we're all grappling with is not everyone agrees on answers.
It's a big problem. It
is a big problem, because then people share the answers they heard, and it just creates even more confusion. And I've said all along that best practices will evolve. It's just going to take some time.
Yeah, they don't agree on answers because the settlement agreement itself is vague. And also when you factor in that different brokerages might have their own buyer broker agreements, and we don't know what terms are in there. It's very much like Christian said, the facts and circumstances, looking at the sales contract, looking at the actual brokerage agreement itself to see if there's some clause, something under other terms and conditions that covers this scenario.
Right. And then the settlement might have some other language that, or the DOJ might have a different opinion on things like that, and we'll have to see how that happens. Jim asked a question. It appears that listing agents will probably get paid a commission, but double dipping is going to be much more difficult. This will greatly reduce the income of many realtors. Too bad. Jim, it's possible that would happen. I have a different take. It's just an opinion, but I think you'll see more deals where it's just one agent, and that agent will make more on that one deal than they would have otherwise. And in those, so you might have more where the listing agent is representing both sides, but that same listing agent is going to have less buyers. And so it should kind of come into a wash, you know, especially in our markets. People will still buy, people will still sell, and they need realtors. We need you guys involved because most of our customers are out of town, or they just don't know what they're doing. And I can't do the day-to-day, I can't hold their hand on every step of the way. So we need you involved, and they'll realize that. I don't think this will drastically reduce income. It'll change where it's coming from.
You know, part of this too, it's similar to having a brand new statute. We have no case law interpreting the statute. Okay, so the three forms NABOR has, two of them require litigation. We don't have one single case interpreting any of it yet. So these vague terms with working with or facilitating, we will have different opinions. And I forget who raised that. Different lawyers have different opinions. That's what happens in court every single day. Until we have a body of law interpreting this stuff, just like we have a body of law interpreting what the seller needs to disclose, latent material defects, which has evolved over the years, we're just going to be disagreeing on some of these points.
I agree. I have another point I wanted to hit on. We talk about amending the buyer brokerage agreement. And I don't think anyone's actually given how to do that. If you've noticed, the buyer brokerage agreements and the amendment, it's just blank. So this is amendment to buyer broker agreement. You have to fill out the whole thing. Well, what do you say? What are you supposed to say in that regard? I've got the language for you. This was something I wrote last night. And you basically copy and paste from the buyer brokerage agreement. Broker shall receive the following total compensation for broker services as follows. And then A, for each property purchased by buyer, blank % of the purchase price and blank dollars. So that's what I would do, copy and paste. In fact, I'm going to put that in the chat feature so that you have it. And if you do need to amend your buyer brokerage agreement to accommodate a different compensation structure, you copy this, you paste it into an amendment, a buyer brokerage amendment, and you have the buyer sign it, you have the broker sign it, and you put in the new amount. So I think that would solve your issues there, and it's very clean. And if you lose this and you don't have it, I just borrowed it exactly from the buyer brokerage agreement. So you can do the
same thing with NABOR versus FARBAR when we're dealing with radon and mold. You just take the same exact language from the NABOR.
Same exact language and paste it, or you can reach out to us and we'll give it to you again. That is not a problem. I thought that could be helpful to you guys, and you'll see that in an upcoming article as well. Sigrid asked, when working with a longtime customer, I send regular MLS listings located in customers' areas or what might be of interest now or in the future. Can I continue doing it without anything signed? I assume whoever wrote the settlement agreement has never worked as a realtor. I can guarantee you they never worked as a realtor. Yes, Sigrid, you can still do that. The time when you need something signed is prior to touring a home. And that would be either touring it with like FaceTime or Zoom and, like virtually, or physically being there, or setting up an appointment for the customer to go in person. That's when you would need that buyer brokerage agreement or the pre-touring agreement in that scenario. I think, let's see if there's any other questions in here that we can hit on. Anything else, Mike, that you have been struggling with or working through?
Yeah, I've been working through a lot of stuff these days, but I am following up on that property pre-touring agreement to see that if the boards would accept it. In other words, if they approach an agent and say, we want to see your buyer broker agreement, and you produce a property pre-touring agreement, will they accept that, or do they fine you because you didn't use a buyer broker agreement? So that's a new twist, and I have approached the Bonita board and the Naples board waiting to hear their answer. And I got an answer from Bonita yesterday. I've got one, I posted to Naples today, and then I will go to Marco, because I certainly—
What did Bonita say, Mike?
Well, it was a quasi answer. She leaned towards accepting it, but wanted to hear what others were saying. So
I love it. How great! So this is,
but she makes a great point. It'd be nice to get a consistent answer rather than one board does it this way, another board.
Yeah, I'll happily be consistent. So this
Yeah.
is the form that Mike's referring to. This is the FAR property pre-touring agreement. It is a one-pager. It specifies how much you are charging, either a flat fee or a gross percentage point of the purchase price or some other compensation amount. In my review, this is sufficient. The problem with it for most people is it doesn't disclose what your transaction, or that whether your transaction or single agency. But the NAR settlement doesn't require that. Now, does Florida law require that you disclose that? Maybe, right? So there's like, I don't remember how that works. But what this really does is it allows you to do a very simple agreement with a buyer so that you can go see the property. And then I would probably, just because we don't know, and because your broker doesn't know, and the MLS doesn't know, is that you would tell the buyer, hey, we're just going to sign this one pager. You can cancel it at any time. There's no obligation. But if we do want to make an offer on any one of these properties, we'll have to sign an exclusive buyer broker agreement at that time. And if you warn them about it, if you guide them ahead of time, they likely won't fight you later. Now, the risk is that they could try and cut you out of the deal because this is not exclusive. This is not does not create procuring cause arguments that then get you paid. This really isn't enough if the buyer were to try and cut you out of the deal. But if you,
I look at this form as something you'd use when you're meeting somebody for the first time and you agreed to give them a day of your life, warning them that if you get along, at the end of the day, you're going to hit them with the exclusive agreement where they agree to pay a certain percentage. But you're getting a chance to get to know each other, trust each other. How competent are you? I mean, why else would the form even exist? What scenario does the Florida Realtors, presume this form would be used in, but for the touring a home?
yeah, I think the form is fine. If I were to make a choice, I'd say you can get paid on this, but your broker's the one that matters, not me. And I've certainly gotten I've stepped on toes over the last couple of months where I'm saying something and the broker's not there yet.
Yeah.
Doesn't mean I'm right or wrong. We're just not there yet.
Well, I was talking to an agent this morning about this form, and he likes it. He does a lot of works with a lot of contractors, and I said the problem with this is you don't have a remedies clause, you don't have an attorney's fees clause. So if you get in a fight with somebody, you don't know the form whether there's something you're going to arbitrate or you're going to litigate. And if you're going to litigate, you need an attorney's fees clause.
Yeah, if we go back to the good, better, best, this is only good. This is good. It's
and it even talks about the realtor may ask you to sign another agreement, so it contemplates within it that there may be another agreement. So
yeah. The other point I would make before we move on is this isn't the only form out there that's like this. Mike, if you want to spend the time getting this one approved, there's an EXP version, there's a California version, there's a Keller Williams version. There's every brokerage out there is trying to create their own one pager, and are they enough? And so, and if within a brokerage, those agents might be trying to create their own form. I was hired, they tried to hire me to draft a one pager for a specific team. And honestly, I could do it. I could make it contractually sufficient, I think, but does it satisfy the broker? Does it satisfy MLS? Does it satisfy NAR? Maybe. That's why I like the buyer brokerage agreement, because you can always say it was created by Nabor, it was created by FAR, it was created by FAR. I like those forms better because it's a pretty good defense. Christina mentions multiple BBAs signed. Wouldn't the date come into play when signed and covering the same territory? Yeah, dates matter, but it's just easy to make a mistake. So you're gonna, I heard people that they want to do an expansive all of Florida or all of Collier County buyer brokerage agreement at this amount, and then we found this one property over here, and now we're going to sign one at 4% or at 5% or at 3%. We're going to change it. Well, you still have this one unless you terminate it. Unless you terminate this or void it out, then you can go with this one. I just wouldn't really go that route. I would try to say stick with one and amend it, or do separate ones that are all specific. each one of them is limited in a sense.
Here's a question I have, guys, and you would have more knowledge of this than me. What's NABOR's stance in accepting Florida realtors buyer broker agreements or FAR buyer broker agreements? Are they going to insist on using a NABOR form, or are they going to accept forms from other parts of the state?
I would imagine if it says buyer broker agreement, they'll accept it, but yeah, I couldn't tell you. I'd have to say, here's what's going on right now. We've been into this for what, 11 days.
Yeah.
And in effect with Neighbor, we have 8,000 testers. And so we're getting questions. You'd be stunned at the questions the brokers are getting now. It's almost like you can't get to anything else because you're going through emails answering questions. One interesting one, Don, that I just had was a scenario where a buyer broker agreement was signed up in Sarasota to show property up there, and then the agent down here in Collier County is also showing that person property down here. And the question was, can I do a buyer broker agreement with them also? And my answer was the one up in Sarasota and exclusive.
And what was the territory? What's I mean, if
Yeah,
the
the
just up
neighbor
there,
territory says it's specifically for Collier and Lee.
Right.
yeah.
But what if
you
the
gotta
one in
see the form.
Sarasota is all encompassing? So until you see the documents, you can't really fully give.
You really can't.
Well, what about the protected period too?
Yeah.
I think so Christina clarified, she was talking about between other agents. So she wasn't referring necessarily to the buyer brokerage agreement, or maybe she was, but she's also referring to this broker compensation agreement. So I guess in her scenario where the dates matter, do the dates matter if you're signing multiple of these? And yes, the broker compensation agreement is like an offer of compensation if that broker brings a buyer. It doesn't have, these forms don't have an expiration date on them that I can tell. So you would have to actually rescind it. You'd have to get, the listing agent would have to send an email rescinding this buyer brokerage agreement.
And obviously,
otherwise they're
be dated
obligated.
before you tore the property too.
Which you said you want this before you tore?
Yeah, I mean, you need something in writing before you tore the property, so to that extent, the date's important.
Maybe. I
Before.
don't know. I'm kind of leaning towards not making this a big thing, because otherwise you might tour 15 properties in a day. I know how hard the realtors work. If they did 15 of these, but then the next day half of the listings expire, what good are these? This doesn't, it's I would say only if you make an offer, you should have this included. You can get it done up front.
But the settlement calls for something in writing before you tore the property with a.
This is a broker compensation agreement, not the buyer broker agreement.
Okay.
So if in that scenario, this is between listing agent and buyer's agent, that form in writing doesn't have to be before showing. It would just have to be as part of your contract.
Yeah, this is the one with procuring costs, which can be a living nightmare.
Yeah, so we're going to dive in a future article, and so we'll clean this up now and we'll say goodbye to you. But in a future article, we're going to talk about procuring cause and how that may or may not have a place in the future, and when does it apply and when will it not apply. But here's the going away present. Don't let procuring cause dictate anything in your deal. Everything should be in writing and signed. I wouldn't rely on a phone call, a text message, or an email. I would have a buyer brokerage agreement, I would have a compensation agreement, I would have a listing agreement, and I would have a sales contract. And I would do all of them that way. From every single angle, I'm covered. That's our goal.
And my point would be, use this thing as an excuse to get somebody to commit to you earlier. Say, those darn antitrust lawyers, litigated this thing, and now we have to get something in writing before we tour the property with you. What a pain in the rear end. I'm very sorry. Well, and also check out, if somebody's flying down, whether they come from a state that already requires it, because it might not be a big deal with them.
Speaking of pains in the rear end, thank you, Dad, and thank you.
I love you too.